Recording in progress.
Good morning. Can everyone hear me okay?
Yes, Your Honor.
Okay,
Yes.
thank you. Okay, I think we're all here. So let's go ahead and get started. Welcome to this session of the 6th District Court of Appeal. We have two cases on our docket, one at 9 o'clock and one at 10 o'clock today. Our first case is number 23-109, A. Peter Aldrian versus Don M. Aldrian. Counsel, are you ready to proceed?
Yes, Your Honor.
Okay, and appellant's counsel, how much time would you like for rebuttal?
Thank you. May I reserve 5 minutes, please?
Yes, you may, and you may proceed.
Thank you. Good morning. May it please the court. My name is Stacey Haverfield. I represent Peter Aldrian, who is the former husband and appellant in this family law appeal. We raised 3 issues in contest to the final judgment in this appeal. However, given the nature of the first issue, we're going to focus on that because, in our opinion, a reversal based on the misclassification of the marital liability renders the need to address issues 2 and 3 unnecessary. So for purposes of this oral argument today, I will focus on issue 1, which is the improper classification of the marital liability. Unless this panel has any questions for me, I'm then happy to address issues 2 and 3. So today, issue 1, the trial court misclassified the liability of the parties. Basically, in May of 2021, the court had 2 items it had to address. It had what we refer to as Judge Bean, which was the party's marital home. It was uncontested that this was a marital property, and it was uncontested that it should be subject to equitable distribution. And then
We all read the briefs and we're all familiar with the facts. To me, your argument on issue 1 essentially boiled down to Frederick creates an exception to the language of 61075. Am I wrong about that?
yes, sir. So it doesn't
yes, he's wrong, or yes, it creates an exception.
No, yes, he's wrong. I apologize. I should have been more clear.
It wouldn't be the first time.
Oh, well, so allow me. What the trial court did was not apply 61075, the subsection 6A1A. So that subsection reads, and I'm looking at it here, so I'm reading verbatim, assets, and let me start up at the top. Marital assets and liabilities are to include assets acquired and liabilities incurred during the marriage individually by either spouse or jointly by them. Yet what the trial...
But what about 61075, B1?
Well, okay, that addresses non-marital liabilities, but we don't have that.
No, that goes, I think it goes more than that. Good. I'm sorry, Judge Myers, go ahead.
No, I think we were going to say I think we were going to say the same thing. I mean, the loan was in the Wisconsin properties were non-marital. Your client argued they were non-marital. The trial court agreed with you, and the loan was obtained in exchange for the non-marital Wisconsin properties, was it not?
Respectfully, I disagree. There was no in exchange for anywhere in here. So we basically had 4 lines of credit. It is undisputed that 97.3, 97.4, and 97.5 were all incurred post-marriage. The fact that the former husband was able to encourage his banking institution to loan him that money because he owned property elsewhere is not relevant. The presumption is because those liabilities were incurred during the marriage, they enjoy a presumption of being marital liabilities, and it is the burden of the former wife to prove that they are not, and she couldn't. It was undisputed.
That's very different than what you said in your briefs. I mean, my understanding is that I think all of the DCAs, if not most of them, and everyone that's looked at it, has decided that when you get a loan by posting non-marital assets as collateral, that those funds are obtained in exchange for the non-marital collateral. Has not every DCA that's looked at the question said that?
Not that I'm aware of, Your Honor, no. And I would respectfully draw your attention to the Ray case out of the 1st DCA, where that can be likened to this, where the husband took out a loan of $70,000 from non-marital property, but the income that was used from that loan was used for the benefit of the two parties, and therefore that $70,000 was considered at the end of the day a marital liability because it was taken out during the marriage. The proceeds benefited both the husband and the wife, and they were spent on marital assets. And that is exactly what we have here. The reason why the bank extended the line of credit is not relevant. This was not in exchange for anything. The value of the...
I don't see the Ray case in your brief, counsel.
It's in the reply brief.
Oh, in the reply. Yes, sir. Sorry, I should have.
I stand corrected.
Okay. Well, and so the equity in these two, because only 2 of the 3 Wisconsin properties were pledged at different points of time as collateral. The equity, I mean, it was undisputed. Both forensic accountants as well as the former husband testified that the value of those properties were not affected at all by these lines of credit. Basically, we had a sophisticated individual who had developed a long-standing relationship with the banking institution, whether it be Dairy Street Bank or then ultimately Tri-City. And therefore, those banks, when he requested it, extended this line of credit. The fact that they knew that they could potentially go after a piece of property in Wisconsin is not relevant. And it was not in exchange for anything. This was merely the bank extending money to an individual who was married. You'll recall 97.3, 97.4 were both extended and incurred in 2014. The parties were married in 2001. And then the $1 million for 97.5 was extended in 2016. And that money went specifically and expressly to buy the party's marital home, which the trial court deemed was subject to equitable distribution and indeed did divide it equally. So it is not fair, and it's not in the spirit of 67075 to allow the debt in the money that went into buying and acquiring these marital properties to be solely the former husband's burden. Equitable distribution would indicate, 1, these were improperly classified as non-marital, and 2, that these lines of credit, they should have been considered as a part of the equitable distribution and divided accordingly. But that is not what happened. We know that the court it flipped the analysis. We know that from reading the final judgment. I'm on record page 1721. I'm just reading from the final judgment. And what the court writes is, the court disagrees with the husband's position that the property remains his non-marital asset, but that because he used the equity, that's an incorrect statement of fact, from his non-marital property for some marital purposes, that the otherwise non-marital debt is converted to marital debt. This would be inequitable. Well, that flies in the face of the Florida statute. I mean, the definition of marital liability starts with a liability incurred during the marriage. That is exactly what we have here. And very clearly and compactly with, I keep referring to 97.3, 97.4, and 97.5, because those are very clean. Those are the original loans. They were used, it was undisputed that they were solely used for either the purchase of a vacant lot on Judge Bean Road, the improvements of that vacant lot, and then improvements of the marital home on Judge Bean Road, and then the $1 million, that's 97.5 of Judge Bean. The only line of credit that had to be parsed out, if you will, was 97.1. And that was the line of credit that came from Dairy State Bank. And the forensic accountant was able to parse through and remove those loans or lines of credit that were specifically for non-marital purposes, and then those loans that were specifically for marital purposes. And if I may, this record is quite large, so I've tried to help a little by pulling record sites and whatnot. But if you go to Exhibit 13, it's Husbands 13, Record 7035, you can see the bubbles and you can trace and follow along with what Miss Griffith did. She's the forensic accountant in separating out the non-marital portion versus the marital portion. And that marital portion, again, went to the purchase of Spanish gold on Upper Captiva. That was the party's first marital home. And it also went to the purchase of a condo on Bosilla, both of which were sold and divided. So both of those were, so the former wife not only enjoyed the acquisition of marital assets based on this liability, but she also enjoyed the benefit once the assets were sold and the proceeds were distributed. So she received from the lot on Judge B, now I'm going back to 97.3, she received $360,000, the former husband received nothing. And she received $568,000, I do believe, from the sale of the Spanish gold property, which was the property on Upper Captiva. And then she also received $142,000 from the sale of the Bosilla condo. So when all was said, again, shaken out, and at the end of the day, she enjoyed at least $1 million from the proceeds of the sale from these three pieces of property, yet she participated not at all in the liability that was incurred to actually permit her to participate and enjoy the proceeds.
Counsel, there's a lot of factual moving pieces in terms of the language of the statute, right? If it seems to me it comes down to what in exchange for means, right? Regardless of what the money was used for, if in exchange for includes, money you receive when you post non-marital property for collateral, then this would have been a loan or proceeds received in exchange for non-marital property. If it does not, if in exchange for does not include proceeds of a loan received, from a loan where you posted non-marital property as collateral, then this loan would not fall within that language, and it would just be a liability incurred during the marriage. So it seems to me all the factual moving pieces are interesting. I know they're important to these parties, but in terms of how the legal question is resolved, it's just what does in exchange for mean? Do you agree with that?
No, I don't. I'm sorry. I don't even think we get there. I mean, these were loans that were incurred during the course of the marriage. So then,
Counsel, but any liability, right, or asset incurred during the marriage is non-marital if it was incurred for in exchange for non-marital assets or liabilities. Do you agree with that?
Yes, sir. That I will agree.
Okay, so I agree. If you just take out a loan during the marriage and it doesn't concern marital assets, then that falls within 6A1, and it's just a loan incurred during the marriage. But if you get it in exchange for marital assets, then it is a non-marital asset. So why would the disposition, the meaning of the word in exchange for, not resolve the case? If in exchange for includes a loan received, in a situation where you put up non-marital assets as collateral, then these proceeds, loan proceeds, would have been, and the liability would have been incurred in exchange for non-marital property. If it does not include your factual situation, if in exchange for does not include where you posted non-marital property as collateral, then it wouldn't be a loan made in exchange for non-marital assets. I mean, he did post non-marital assets, what you argued were non-marital assets, as collateral for this loan. So why is that not dispositive of the issue?
Because, Your Honor, that does not meet the definition of in exchange for. That is not what that provision.
Hold on, I didn't ask you. I totally understand that you're going to argue it doesn't mean that this does not fall within exchange for. I'm just saying, is our resolution of that issue dispositive of issue number one in your appeal? How we decide that? if we agree with you that it's not in exchange for, then it's not, then this loan was marital. If we think it is in exchange for, then the loan is not marital. Just answer that pre-decision, and you can give us your argument on how that issue shakes out, but just tell me whether you agree that whether the resolution of that issue is dispositive of issue 1 in your appeal.
There, I think you are correct. I think you are correct. I think this is a legal determination. I think the trial court failed to properly apply the statute and did not give these lines of credit the presumption that we believe should have been applied. The former wife did not rebut them. And then further, the former husband put forth substantial competent evidence to show that the proceeds from these lines of credit went specifically and expressly to the acquisition and improvement of marital property, and both parties benefited from that specific property or those properties, because we're talking about a few.
Yeah, but not what the money was used for doesn't affect the language of the statute. It was either the proceeds, the liability was either received in exchange for non-marital assets or it wasn't. And it doesn't seem like you dispute that the non-marital assets were posted as collateral for this loan. So to me, that just means we need to resolve the legal issue of, aside from the facts of this case, not because they're not important to the parties, but just because they're not, relevant to the legal issue. When someone posts non-marital assets as collateral for a loan, is that loan received in exchange for non-marital assets?
Okay. And I would argue that your legal conclusion or your legal determination should be no, in light of what we've got here. So there was no equity. That's a misspeak. There was no exchange for. Those pieces of real property in Wisconsin that were used as collateral were not affected at all. It wasn't as though the former husband had to trade in something to get something. He went to the bank and said, hey, would you give me $1 million? And I think part of his testimony is it related to the Judge Bean home in the $1 million line of credit. He called the bank and said, I need $1 million. I'm going to buy this property on Judge Bean. There was no exchange for. I mean, to posit that in light of these facts, where there wasn't something that the former husband received to qualify for an exchange for. I mean, that's like, trading debt for equity. It didn't happen. He went to the bank and requested a line of credit, and because of who he is, he got it. So the collateral is not relevant. It, in fact, stated affirmatively, it's irrelevant to this analysis. There is no exchange for. And the reason that there's no exchange for is because that property wasn't affected. He could sell the property.
What case do you think is the strongest case for that proposition?
Well, Judge Cohen, admittedly, I did not find a lot of cases on this particular issue dealing with these very specific facts. I would find cases where perhaps the court didn't address the classification at all. Well, that's not really what happened here. The Ray case is as close as I could come. And of course, the Frederick case does something in reverse. And so I
shouldn't have interrupted, Counsel. Finish answering Judge Cohen's question.
Oh, I'm sorry. So I could not find something that made me happy, frankly, that was directly on point to support what I'm saying. However, we do know that cases that deal with the in exchange for are things like a refinance of a non-marital piece of property and then trying to get that refinance included as a marital debt. Well, that was the in exchange for. So they were able to take equity out of whatever non-marital property. So there's the exchange. And then they have this liability over here that they wanted to divide 50-50 when the your
differentiation of those cases relies on the fact that here the amount he took out didn't change the balance of the loan because he had some other loan on it before, right? I mean, rather than just refinancing the debt and taking cash out, he refinanced the debt and didn't take cash out. I mean, the ultimate balance on the loan, he had some pre-existing loan and he had equity on the property, and at the end of this refinance, the overall amount of equity was the same. Is that the difference between your case and those cases?
I'm not so sure I fully understood your example. I'm sorry.
The refinance case where somebody refinanced and took equity out of the house, meaning they took a cash out, right? So they had a $200,000 house, $100,000 loan, and they take out a $200,000 loan. right? So that they take out $100,000 cash out in addition to, you know, the original $100,000 liability. Here he posted the properties as collateral, right? This was I understand he had an existing line of credit. The collateral on the loans changed just like it would with a refinance, right? A lien was put on these properties or maintained on these properties just like in a refinance, and he got money out to use for something. Now he used it for a marital purpose, and I take your point, but he did just like the refinance cases. He posted this property, his non-marital property, as collateral for this loan and got money in exchange, correct?
But no, they're two different, those are apples and oranges, those two examples.
Why?
I mean, in the case of the refinance, there is an exchange. You have a non-marital property, you're able to take additional monies out on that non-marital property. That non-marital property is directly affected by how much money has come out. And then you're left with. Your
client took money out of this property and used it to buy Judge Bean, right? I mean, he had a line.
No.
That line of credit was secured by the marital properties, and presumably that line of credit was at a certain balance. And when he got money out, the balance increased.
No, that's not my understanding of how these properties work. And I'm seeing my time tick down. I apologize, but I wanted to save a little bit for rebuttal.
We'll give you a couple minutes for rebuttal. Go ahead and answer the question.
Thank you. Well, so no, that's not my understanding of how this worked. I mean, Mr. Aldrian's testimony, the former husband's testimony at trial, was that he could buy and sell these properties. He was not restricted at all based on his lines of credit. And in fact, he did buy and sell certain properties, you know, up through getting these last three that were used as collateral. So these properties were not affected at all. There was no equity taken out of these properties. The value of the properties did not increase or decrease based on what payments were made, what payments weren't made, you know, how much money was taken. That's not the case. Basically, he got a personal loan, and that, I guess that would be my example. If would we be having this discussion if the former husband just got a personal loan and there was no collateral? Because really that's what happened. This was a line of credit that he received based on his goodwill and his longstanding relationship with the bank. It has nothing to do with an exchange for anything. And I think, unfortunately, going down that road is dangerous. The source of the collateral does not matter. I mean, that does not matter. The bank loaned him the money, and it was unaffected. The properties remained unaffected by the lines of credit. With that, I'll be quiet.
Okay, thank you, counsel. We'll add 2 minutes to your time for rebuttal.
I appreciate that. Thank you.
Okay, appellees, counsel, you may proceed.
Good morning, your honors, and may it please the court, Jonathan Mann of SSRGA on behalf of the former wife. I think the court has accurately identified the issue and the disagreement in the case as to issue one. 61075 6B1 states non-marital assets and liabilities include assets acquired and liabilities incurred.
How was this exchange? What was the exchange? If he's got property and you know, and the bank says, well, you know, the loan, you know, we'll collateralize it, you know, with this property, but we're not giving you any additional monies. We're not increasing your debt ratio. How is that in exchange for?
When the former husband posted those Wisconsin properties as security for the line of credit, our position is that brings it within an exchange. There was.
What's the exchange? Where is there an exchange within that transaction?
His liability associated with the properties in exchange for what was essentially his equity in the properties. They were owned free and clear. There was testimony both from the former husband and from the former wife's accountant that at times the bank would require additional collateral. Properties would be put on and taken off depending how much former husband had borrowed on those lines of credit. And so I don't think you can sever his liability under the line of credit from what he was doing there. I think that the trial court accurately saw through the attempt to do that, and concluded that what the former husband was doing was obtaining his equity in those non-marital, premarital Wisconsin properties, and that his decision to then use those proceeds to acquire marital properties does not create a debt, a marital debt for which the former wife would
But
be.
it's not like those properties were sold or otherwise, utilized to purchase the Judge Bean property.
That's correct. That's correct. They were not sold.
So I think that the other, I don't see a difference between this case and the house refinance. There was an existing line of credit and collateral moved on and off of it. But at any given time, the bank's willingness to actually cut a check, they cut this check, right, in exchange for these assets being put up as collateral. And to say that they're just completely disconnected, I just think is completely wrong. I mean, the bank required collateral for the loan, or it wouldn't have given a loan. And other courts that have looked at this have said that when you post non-marital property as a collateral for a loan, the debt that you receive as a result of posting non-marital property, as a result of posting the non-marital property as collateral, is received in exchange for it. So I think you followed in those cases. I'm just wondering whether those cases are wrong, right? I don't need you to differentiate them. I'm wondering about just the words "in exchange for," like when you post something as collateral, do you exchange it? You certainly give the bank a right to take it, and you certainly receive the money from the loan in exchange for giving the bank the right to take it. But have you actually exchanged the asset, given that Ford is a lien state, right? The bank has a right to take it. The bank doesn't own the property. You still have a right to sell it, provided you satisfy that loan. You own it in fee simple. Has it been exchanged?
That's correct, Your Honor, and I agree with opposing counsel to the extent that I did not find cases that hit this exact scenario, despite how hard I tried. And then I would default back to the language of the statute and the fact that the former husband was attaching a liability to his non-marital property and then using proceeds that were exchanged for that liability.
How is he using proceeds? I mean, the bank, might have relied upon the fact that he had this collateral, but there was no transfer, there was no exchange. They simply said, well, okay, it's collateralized, and there's sufficient collateral for us to go ahead and give you this loan. But none of the properties in Wisconsin were impacted by this transaction. There wasn't anything that exchanged as a result of this transaction. Right?
That's correct. That characterization of the facts is correct, and that's the situation that we're presented with here. I mean, I would like to spend a few minutes on the Frederick case, which I know the former husband had in the initial brief spent some time on. Frederick, to me, is distinguishable because in that case you had the wife had signed on the mortgage that was taken on the former husband's premarital home.
Do we know if Wisconsin is a lien state or a deed of trust state?
I do not.
All right, so Ford is a lien state, right? When you give the bank a lien, you give them the right to take it. In deed of trust states, technically the title to the property is held in trust. You give up title. So it seems to me that whether Wisconsin is a lien state or a deed of trust state could be really relevant here, because that would affect whether or not there was actually an exchange of the property.
Well, I don't know how we're going to resolve that in this oral argument, but let me just real quickly ask you, about the fact that there were no findings made under 610751, as to the unequal distribution of the judge being property. Isn't that error not to make findings of fact if you're going to make an unequal distribution?
But the court made an equal distribution. The court did make findings under that subsection of the statute, and the final judgment states that the default position, paraphrasing, but the default position is that there will be an equitable distribution of the marital assets, and that's ultimately what the court did. And so when the former...
So the findings don't have to be spelled out if it's 50-50?
There are findings in the final judgment regarding the judge being property. The court finds that it would be most equitable to divide the proceeds, and the court noted that it didn't have the ability to order partition because at the time of the final judgment there wasn't a claim for partition in the parties' pleadings, but the court decided that it would have to divide the property 50-50.
But it didn't go through all of the factors in the statute, in the judgment, right?
It did. I was going to say, counsel, I'm looking at subsection 3, and it says, in any contested dissolution where you don't reach a stipulation, the distribution shall be supported by factual findings in the judgment or order based on competent substantial evidence with reference to the factors. It doesn't say that the findings have to reference a specific piece of property. And I'm looking at the judgment, and I'm looking at looks like page 8 of the judgment, and it looks like the court started with the first factor and went through each one of them.
That's right. That's what I was referring to. The court went through each of the factors regarding the equitable distribution of the parties' properties. So as I was mentioning, I do want to go just to address Frederick, as I said, that in that case you had the parties both signing on a mortgage, and the question was, can the former wife be held liable for this, or can the former wife be held liable? Can it be considered a marital debt, given that the wife signed for the mortgage, as did the husband, on the non-marital property, but there was not evidence, or there was conflicting findings as to what had been done with that property. But the more I read Frederick, the more it appeared to me that had the wife not signed on that mortgage, it would have not been a question. And Frederick actually supports the former wife's position in this case. That's, unless the court has further questions, that's all I've got. We would respectfully ask the court to affirm the final judgment. Thank you.
Thank you, counsel. Can we put 2 minutes on the timer?
Thank you.
Okay, you may proceed.
Thank you. I just want to go back to the in exchange for, and the lines of credit were not exchanged for anything. The equity in those properties were not affected, and this is not the factual scenario that is met given the language in the statute and what transpired here.
Counsel, do you know whether Wisconsin's a deed of trust state?
I don't. I don't right offhand know.
If it was, that would mean that title transferred to the properties, wouldn't it?
Yes, and title did not transfer, which then, and there was testimony in the record on that, because the former husband testified that he was able to buy and sell the different Wisconsin properties, you
can still buy and sell in a deed of trust state, but it goes to the technicalities of how the mortgage worked, right? So Florida's a lien state, right? We all those of us all practiced, or in banking know that. In a deed of trust state, it's more like some states do a car loan where you have a third party kind of hold title. Now you can still buy and sell, right? But you pay off the loan and the third party transfers the title for you. Just like if you are, just like you have a car loan and the bank holds the title to the car, you can still buy and sell a car. When the bank receives its proceeds, it gives the title. that doesn't change the fact that it doesn't affect your ability to use the property, but as a technical matter, it affects who holds title.
I see. I'm not, so to answer your question directly, I don't know. However, I'm not sure for my argument that's relevant, because I will then also say, and there was testimony in the record about this, that the former husband bought and sold properties and was not obligated to pay off these personal lines of credit. So as Judge Cohen was pointing out, there really there's not a connection. There was no equity. That's a misspeak. There was no equity taken out. The former husband did not receive anything like in exchange for these personal lines of credit. These lines of credit were taken out based on his personal relationship with the banking institution. The collateral is not relevant. And even to your point, Judge Mize, if it were relevant, then it shouldn't be. And so, perhaps these cases that you came upon, need to be distinguished from this fact pattern. But as the record shows, and it's undisputed, these lines of credit were taken during the marriage, used solely for the acquisition and improvement of marital property, and the former wife directly benefited from the proceeds of all the sales of these pieces of real property. We respectfully request that you reverse with instructions to the trial court to classify those 4 lines of credit as being marital and then recalculate the equitable distribution worksheet accordingly. Thank you.
Thank you, counsel. We'll
Thank
be
you,
in
counsel.
recess until 10 o'clock. Thank you.
Thank you.